Evening. Welcome to the Tuesday, March 18th meeting of the Town of Warren's Planning and Zoning Commission. Before we begin tonight's proceedings, I'd like to ask those seated at the table to please introduce themselves.
Tamara Costello, Zoning Administrative Assistant.
Brian Miller, Town Planning Consultant.
Paul Kaplan.
Ozzie Parenti.
Paul Denise, Zoning Administrator and Enforcement Officer.
I'm Commissioner Walter Clark. Commissioner Judy Smith Morgan is due to arrive shortly, and Commissioner Rick Mangione cannot make it this evening. I'd like to point out to our one person in attendance the location of our emergency exits. The main one is to my right, your left, in the middle of the room. The other two, again, are to my right, your left, in the hallway. The first one immediately upon entering the hallway on the left, and the final one at the end of that hallway. I'd like to ask for motion to move the agenda to here numbers 3, 4, and 5, and followed by 1 and 2.
So moved.
All those in favor signify by saying aye. Aye. Unanimous. First item on the agenda is old business. I had nothing under old business. I did have one item that I asked Mr. Miller to look over, that bill that was in our packet at our last meeting, the House bill that Paul had put in our packets at our last meeting. Mr. Miller's going to review that and let us know if there's any changes or modifications to our standards, to our regulations that might be necessary. Is there anything else under old business? There being none, we'll move on to new business. The only thing that we have under new business, I'd like to present Mr. Kaplan on his appointment.
Thank you very much. Did I not stand back quick enough?
No, I guess not. Were you unaware?
I was unaware, but I am aware now.
It says, we are pleased to inform you that you have been nominated to participate in a land use leadership program this spring sponsored by the National Fish and Wildlife Foundation of Long Island Sound.
I don't even know how to spell fish.
Well, apparently you can look into it and see if it's something that applies to us, and if you want to participate in it or not. That's something you can evaluate once you know this. But they put your name forward, so somebody's very pleased with you, apparently.
Okay.
And that was all that I had under new business. Does anybody else have anything to discuss under new business?
No.
We'll move on to formerly item number 5, which is the report of the zoning enforcement officer.
Just continued a lot on policing illegal signs. I had quite a few, at least 8 meetings with different merchants in the past 2 days. Some of them were interested in taking out sign permits. Some of them were interested in seeking variances for some signs that were up and determined to be in violation of our regulations. A couple meetings were with some individuals just to appraise them of the Commission's work on some proposed new regulations, and if they so desire to attend the public hearing on the matter. Had a number of meetings also in the First Selectman's office. Well, not a number, but 2 or 3 in the First Selectman's office. And there's a couple of them scheduled with Vinnie for next week on that. Some of the signs that we've gotten included frozen ropes, the Golfer's Warehouse, and bringing it into compliance at least, I'm going to say 20 to 30 other signs. Apart from that, you've got a couple other abatement orders for residential violations. There's one violation on Lambert Road. This is about the 3rd or 4th time I've issued this violation. I'm not going to award any additional days for compliance here. I also cited there is a single-family residential dwelling occupied by a tenant who is running a construction and landscaping business. I sent abatement orders out to the homeowner and to the tenant as well, and I had just phone discussions with both of them. It was a quite large violation in terms of the scope of equipment and vehicles that are there, and they are both aware that no additional time will be granted.
What's the address?
It's 500 Lambert Road. You've got a copy of all the abatement orders there, and I think there's a couple, 2 or 3 other residential abatement orders you might have gotten on that. So, other than that, the phone's been just ringing off the hook, mostly with signs and stuff like that lately. But we have the time to do it right now.
Okay. Is there anything else, Paul?
That's all I have.
Are there any questions for Paul? In which case, we'll return back to item number 1 on our agenda, which is a review and discussion of proposed sign regulations. I think before we get to Vinnie, we can discuss Brian's recommendations, because they seem to be a little bit quicker.
Yeah, I didn't do a legal brief like Vinnie did. As you know, I received this yesterday, so my review was very functional, and Vinnie raised a lot of legal issues. I just sort of looked at it very from a nuts and bolts perspective, and also the only thing that I really did was take the discussion draft that I received, that I think you all received, the summary proposed amendments, it's not dated, and go through.
Thank you, I'm sorry. And go through those amendments and just kind of look at, see if there was any real glaring issues. The first issue I had was, you're talking about window signs, and you're regulating that, and I think that's fine and permissible. I just think they should be defined, and we talked about, are they taped to the window, are they an inch behind the window? Again, you're opening up a new issue of regulation, so it's probably worthwhile to stick another definition in on that.
And we should put that under 385, 185 definitions, correct?
Right, yeah, where you have all the other definitions.
Why don't we go over that? I just jotted down something real quick to throw out there as far as a definition of window signs. I wrote a sign attached to a window or placed in a manner that view is primarily through the window. I think that covers the intent of what a window sign is, and that if you have something that's hanging just behind the window, that should be considered a window sign, if the intent is to be viewed through the window. Is there any suggestions or objections to that wording? Improvements to that wording?
I just would, at some point, I think you might want to say within 12 inches of the window, because if it's something that's set back 2 feet, even if you could see it through the window.
Well, that's why I put primarily, so that we have a judgment, so that you can look at a window and see what's, you wouldn't want for instance, a mannequin placed in a window. You wouldn't want to consider that a sign. So, and the primary view of, say, a mannequin is to be viewed both ways.
Can you read that again?
I wrote a sign, and of course it'd be, the heading would be window signs. A sign attached to a window or placed in a manner that the view is primarily through a window.
That's good.
So we can go ahead with that definition? Ben? Pass the test?
For tonight, I passed the test, yeah.
Okay.
Before you see another report on it.
Okay, so I'll make that change. And go on, Brian, please. Thank you.
On proposed 383-188, capital AE, that talks about, you use the term in aggregate, and I would just suggest that be defined. I know what your intent was, is that on one side, if it's 8 feet, both sides. I just would
Yes.
suggest that be clarified.
So again, include the clarification under definitions?
Yeah.
Okay.
On 3, well, I realize this is also notes. On the second page, it says 383-187, improve the definition. I wasn't sure of why. Second page of your report, on the title of it.
1 second.
And this might just be, again, I didn't have a chance, I kind of went over it and jotted down some questions.
Let me just take a look and see.
Under existing regulation 383-187, 383-187 2D.
Well, I think we do that, though, in the... We actually do that, and that's what I think we've done in the proposal, is improve that definition. If you go down, in the note below, it says in block text. I don't know if yours is... Did you copy these in color, Tammy? No. Oh, okay. If you look at it, it says existing regulation 383-187, and I have 383-187 2D, improved definition, and just down below that I have proposed 383-187 2D.
Okay.
And that is where I hope I improved the definition.
Well, okay, I just wasn't, I was kind of going through this yesterday
By
afternoon.
adding the italicized words.
Correct, yes.
Okay, great.
Yeah.
You also, on the temporary signs, there's just, sometimes you say within 12 feet of the public roadway, and then in one place there was, or within the public right-of-way.
And that right-of-way should be included. Whenever we mention a roadway, we
Yep.
should include the wording for right-of-way, okay?
I had a question, and I noted for myself on the issue of structural and aesthetic. I think Vin will get into that a little bit more.
Yeah.
So I'm not going to talk about that. 383-190. As I was looking at it, and I looked at the existing regulations of frankly, I wasn't sure what it meant. And
You're talking about the existing text.
the existing, because, you reference it, so I looked at it, and I don't know, there's words missing or something from it.
Under 190B.
Well, the existing text, site plans and special exceptions.
what that was for, Brian, is that sometimes in the course of site plan approval and review, the signage was also reviewed and approved by the commission. I think that's what it means.
Well, I would suggest while we're looking at it, that maybe whatever we think maybe we just play with the language while you're tearing this thing apart here and looking at it.
Well, we hope to be rebuilding it at some point.
Well, yeah, I mean, it's like the engine's apart right now. 383-190B, very minor point, I just would say in accordance with the following standards. And I also question, for just discussion of the commission, on 383-190B7, where you talk about these commercial construction signs, and you say at the time of the building permit, I just offer why would you permit it? There may be some reasons you want to permit it after it's approved by all the land use boards.
That very item was brought up in a discussion Paul and I and a couple other people had with a developer, and he wanted to put up a sign, and we said, well, we're working on that now. I said, currently it's, although we allow it by practice, we don't allow it in our regulations, and we said, this is what's been proposed, and his first question was, do I have to wait till I get a building permit? Can't I do it when I get the approvals? So he brought up the very same question, so I guess that's a question, for the commission. Do we want to change that standard to, instead of the building, typically, Paul, how, after approvals, is there generally a long wait, or depending on the project, there's really no general rule?
In terms of when they want to put up a sign?
Well, in terms of from approval to beginning of construction, or the pulling of the...
I would say, generally speaking, those signs don't go up until construction starts.
So when they pull a building permit.
Right.
All right, I just throw that out. If it's not an issue, it's not an issue. But I know on some major commercial projects, sometimes they like to start marketing it or create a buzz before the actual building permit is pulled on it. And what you might do is let them do that by, a special exception or something.
So we could...
Yeah, for major commercial projects. For little projects, it's not an issue. I don't think it's an important issue. I don't know if it's not an issue, it's not a concern, then I would just dismiss it. But I just sort of raise that as sort of.
But what
a
you're
certain
suggesting
point in
is
time.
that we perhaps keep the proposal, that is, the building permit, then create a special exception, say, under a three-quarter vote of the commission or something of that nature?
Right, or maybe as part, even you don't have to go through a whole special exception, just as sort of a special request that they have to come in and explain to the commission why they need it, and they need a supermajority or something of that nature. And just so that maybe it's not an automatic thing, but you might have some extraordinary projects that there's a lag time in doing the building construction or the marketing or something like that you might want to leave yourself an out on. That's all
That
I
might be
suggest.
helpful to businesses.
Yeah,
Possibly,
that's what it's...
Rather than have that cold black and white thing, is that they have to wait for the issuance of a building permit.
So we could insert, we could create another, just say, number 8, and just refer to, let me just get my lettering correctly. We're discussing 383-190B, and in 383-190B7, after the issuance of a building permit, or in accordance with 383-190B8, and we could create the statement 8 that would allow it under certain circumstances. Would that be proper?
I think so, yeah.
And is that something the board wants to, as Judy said, I think Judy made a good point that, especially in the case of a large development where it takes a long time to get these things through, but they might want to begin promoting the project before, and they would come before the commission, and we could, at that time, have the
We
ability
would have the
to.
discretion to
Yeah.
say yes or no, but at least
Okay.
it keeps the option open.
And I think Judy made a good point, we want to promote, especially with a large project, we want to give them the opportunity to get as much time to promote it as possible.
I imagine it occurs where a building permit expires. Does that ever happen, Paul? Or somebody pulls a building permit, it expires?
That hasn't happened too often for a commercial or industrial property.
Okay.
It costs a lot of money to pull a building permit, so they're usually pretty serious, I think, by the time they come in and do it and come in with all the plans and everything.
I think one of the cases that, why I put in what made me think about it, I went through, when I drafted these, I went through a bunch of different regulations in different towns and also in a couple different books. And one of the reasons I pulled that too is when you think of the Stu Leonard sign. It's been up there for 4 years now? It's not looking the best any longer. So we may want to, I think it is a good idea to have that option.
Well, why don't you then also say that you allow it for a 6-month period, and if they can't get their act together in 6 months, then it's got to come down.
Well, if we're going to have the discretion to approve it, I assume that we'll approve it for a period of time.
Well, then you could specify that, I would say. But I agree, I mean, that's certainly an obvious example of a project that's been prolonged.
Yeah.
Or maybe they could have the ability to seek extensions to the 6-month period, depending upon what, development issues have
But they
come.
have to come in and, at some point, you say, take it down, and when it's settled, then come back, yeah. I think that would solve it. The commission may limit time of it or something.
Okay. So that addresses Mr. Miller's comments. Now we're on to Mr. Marino's comments, which I get a feeling aren't going to be as brief.
This will be very brief. Let me open just by saying I long for the noise ordinance. This is not an easy undertaking that you're doing. You should be applauded for your efforts, and you should know that although the United States Supreme Court has addressed the issue in some instances, it has not addressed it on the issues that we would like it to have. The Second Circuit has addressed the issue in some instances, but the Sixth Circuit has disagreed with the Second Circuit, so the U.S. Supreme Court might alter the universe at some point in the future, should it ever get that far. Might even be the town of Orange that gets us there at this rate. And the Connecticut Supreme Court has not addressed all of the issues as well, but the appellate courts have been somewhat helpful. And as you can see from the stack of paper, these are just some of the cases that we've reviewed in trying to come to a clearer understanding of the issue and the undertaking that you're doing. I think first, before we get into the real, the constitutional issues, it's important to recognize what your powers are. We start as a commission with 8-2, and that's where you derive your power to regulate on a local zoning basis, and that's really where we're confined. And notwithstanding the fact that the United States Supreme Court may have said, you can regulate for aesthetics, the Connecticut Appellate Court has said 8-2 does not allow you to consider aesthetics for purposes of regulation because you're limited by 8-2 to height, size, and location. So, we have to we can't get too excited about, the federal courts in this. We have to come back to our home rule, which is 8-2, and that's where we're governed by. So I try to give you as much of an overview in this some 20-page memorandum, but for the most part, it's going to be whittled down to what does 8-2 allow, and then in those instances where you want to try to work in aesthetics and whatnot, how can the regulation be worded so that it will withstand judicial scrutiny? Because at the end of the day, that's what this exercise is all about. Otherwise, we can leave, things as you have them. What I've tried to do is open up with, this is your proposal, go through a dialogue on what the case law is, and then conclude the section on recommended changes. And in the first section, which discusses the regulating of the structural and aesthetic quality of signs in Connecticut, if you jump forward to page 4, where you get into a bit more of the analysis, again, I get to the heart of the issue of, notwithstanding the constitutionality of the aesthetic issue, it's really, the question is whether 8-2 provides local zoning commissions the authority to regulate the structural and aesthetic quality of signs. You're only given the power under 8-2 to regulate the height, size, and location of signs. So in order to really avoid the issues, what you want to do is you want to word your regulations in such a way where it goes to the height, the size, and the location of this. Now, as I was going through this exercise with my associate that was helping me draft this, I was trying to give him kind of a different view of the world, and at the end of the day, for example, what you're proposing is temporary signs must be of a structural and aesthetic quality that does not have a negative effect on the health, safety, and welfare of the other commercial enterprises. If you simply change that to change the word structural and aesthetic to they must be of a height, size, and location, you may be accomplishing the same thing, because again, you're not defining what your structural and the aesthetic quality is, and therefore simply by changing the words, you're taking the statutory verbiage and you're putting it into your regulation. And you're avoiding the issue of whether or not you're allowed to regulate based on the aesthetics.
Was it the commission's, I think that goes a long way to taking out the word aesthetic and putting it into where 8.2 allows us. But I think that, and I think that the aesthetic wording there was based upon the height, size, and maybe not location, but let's go with location anyhow, and not the actual content or anything like the lettering of that anyhow. So I think that, at least from my perspective, I think that takes us there.
Okay. And I think that the second suggestion that you had there is maybe too vague.
Yes.
The second alternative.
Really what was driving this section, if you look at page 2, there's a Connecticut Supreme Court decision that came out of Greenwich, the Caplabo v. Planning and Zoning Board of Appeals. And in that case, really, as I state, is the Supreme Court of Connecticut avoided the issue of aesthetics. And it went back to whether or not there was an authority to regulate signs. And the court concluded that the town could not regulate, in this instance, it was the colors used on advertising signs. And this discussion is going to play out throughout the entire dialogue that we have, and you'll find that there's repetition as we move forward. So I'll try to short-circuit that later on in the discussion. But so here we have a court saying, from an aesthetic standpoint, you can't regulate color as a basis for regulating signs in your ordinances. So again, by getting to,
But it goes back to 8.2 not having that authority.
Exactly, but
Not giving us the authority.
other decisions have stated, well, let's look beyond the regulation, let's look at the record. So as you're going through your public hearing process, to the extent that you are stuck on the word aesthetics and you want that in there, you're going to want to make sure that what is within your record is sufficient evidence to support that this is not based upon color, this is based upon preserving, and promoting the health, safety, and welfare, and going toward height, size, and location.
What do we do with structure? Is that covered under the building
I
department,
think
Mark?
that must be covered under the building department,
Yes.
correct? Because
Yes.
he has the authority to do that.
Yes, and that's where, when you're getting into, where I saw it as height, size, and location, you can get into the word, it goes to the heart of the word structure, because, a structure can be something that's 1 foot off the ground, or can be something that's 100 stories off the ground. And what you're doing is simply saying, the temporary sign must be of a certain height, a certain size, and presumably you're going to delineate what that height, size, and location is.
We do go we do go into size. Height is already covered, correct, under our regulations. We may have to go into that further, though, for a temporary sign, because we don't address it, we only address it for the pylon signs. So if we, and this is all, to backtrack a little bit, we still don't know if we're going to allow the temporary signs, the roadside temporary signs, anyway.
Just one thing, Bo, that I forgot to mention, and I had a brief discussion with Vinnie about this today, but most of our signs up in the Marshall Road area in the Light Industrial 2 District, I'm going to say 80% of them have variances for low-lying signs. Our current sign regulations require no signage to be located between 3 feet above grade and 10 feet in height. And all of the users up on Marshall Road, from DiCello's to Baker Properties to where the restaurant warehouse is, have all received variances to get low-lying campus-like signs. So you might want to take a closer look just at the signs in the LI2 district and differentiate them from the standard, which is exactly the same from
Okay.
Yeah, I
commercial
mean,
district.
going to that issue, it's, if everyone's getting variances anyway, and it seems like it's more pleasing to have something at that height than have something 10 feet off the ground, it seems nonsensical to make the applicant go through that extra expense, if as a commission you deem it appropriate today to have those lower lying signs. You might as well just alter your
It
regulations.
just seems that the industrial users don't prefer that high-standing 25-foot.
Now, I have one
height
question
sign.
as far as that goes, though.
Yeah.
We discussed the problem with real estate signs, that we may not be able to have a different standard in the residential zone and as opposed to commercial zones. Would that same theory apply to the light industrial zone versus a commercial zone?
Generally, as long as you're providing enough opportunity to display the message, you can vary the size.
Okay.
So so I don't think that's going to be an issue.
Okay.
I'd also, I think that point about those monument signs is that they generally, they are preferred in kind of office industrial environments because frankly, they look a little,
Sure.
they look better. And I would also just, while you're, again, tearing it apart and putting it together, is I'm not sure that those would necessarily be a bad alternative as opposed to a freestanding sign, even in the commercial districts. That if a commercial plaza wished to put this monument sign instead of a pylon sign.
I think the problem typically there is when you're dealing with the post road, for instance, where there's heavy traffic, and much more traffic, you might be impeding too much vision coming in and out of a shopping center with a ground-based sign. I think it's.
Well, it depends where it's located. I mean, and maybe you even just permit that as a special exception, because I do think they look better. If you have a series of these low-lying signs that are hugging the ground, it looks better than these signs that are stuck up on a pole. And certainly, if you do it by special exception, obviously going back to the point of safety, that obviously would be a consideration. You make sure that the sight line, so it's not right up at the intersection where it's blocking somebody's view of the traffic, but if it's set back, 12 or 15 feet, then maybe. Again, it just may be an option that you want to permit under special circumstance.
Thoughts?
I mean, I think we'll get valuable input when we have the public hearing and
Okay.
hear from the businesses and the merchants on Route 1 as to what they think might work best for them. But clearly, I think the campus-like lower-level sign works in an LI2 zone.
Yeah.
And it may have some appeal in the commercial, but,
How many tenants are in a particular center and.
Right.
Yeah, and also the frontage and so on. So, you know, I think, my fear is that if we try to do that in the commercial zone, that we're gonna, we're gonna have another couple pages of regulations.
Right, and we'll have signs that are run all the gamut, you know, and.
High, low,
Well,
and, yeah.
you want to have consistency.
Yeah.
And also, you know, along your post road, you know, the higher signs work because from a distance, you can then see, you know, the upcoming shopping center. Where, when you're in NLI2, where it's more of an industrial, light industrial, you know, there's less
Larger
traffic.
parcels, you
And
know.
larger parcels, larger, so,
Yeah. So I'll draft something for the BOP and the light industrial zones to address the type of sign. As you said, if we've been doing it by practice, by variance,
Maybe
let's do
that
it.
should be the
I mean,
standard.
And I agree with the comments made by Mr. Miller and you know, everybody here, that in that type of a setting, it certainly seems more appropriate.
Perhaps I'm thinking ahead a little bit on what to do with that, so.
Okay?
all right, just keep, before we move on, just keep in mind, to the extent you want to include some aesthetic language in here, the courts have not stated that that's going to invalidate your regulation, okay? In fact, the Burns decision, Burns v. Barrett, which is a Supreme Court decision, ruled that the presence of aesthetic criteria in a regulation would not invalidate it as long as there was another more generally recognized ground for the zoning decisions.
What is the difference between aesthetic and height, size, and location?
What side do you want me to argue? One could argue that there is no difference. I mean, from an aesthetic standpoint, what you're trying to do is promote continuity within a district, and therefore aesthetically, it's more pleasing if the signs are all of the same size, location, and height, so that within the district, you know, there's a beautification or something that works. You know, again, going back to our prior conversation, you wouldn't necessarily want to have a post road with low-lying signs and high signs because it's too much of a mismatch, you know.
Aesthetic, I guess I'm trying to figure out if aesthetic is an amplification of, and a more detailed description of height, size, and location, or is it just a functional equivalent?
It can become somewhat subjective. I mean, what's aesthetically pleasing to me might not be to you.
Which
You
is
know,
the point that you brought out prior.
You know, I mean, it could be to a point where you have all signs need to be of a certain material at a certain height and have a certain, you know, again, you want to have continuity. So I'll say, although I said you can't do it, of a certain color. Okay. Again, what you're doing tonight, or ultimately through the public hearing, will be the regulation until a court says it's
But
not.
I think the point you made before, too, was that height, size, and location, we are specifically addressed under A2, that's the authority we have to address that, and that we don't, under A2, have the authority to address aesthetic
Right.
qualities. So that's why, if I understood it correctly, that's the main
Right.
push for having it,
Right.
you know, to that thing, and then we can,
It sounded like what Paul was saying before was that it wasn't his understanding that we were trying to go beyond height, location, and size. I mean, really, to.
I'm not sure we intended that as a commission,
Right.
and therefore the word aesthetic, I think we get to where we want it to go, or at least where I want it to go, was height, size, and location.
Yeah.
Did it?
But if
and
you
as
use the
were
word
saying, you know,
aesthetic, though, I mean, you're definitely bringing in other considerations. You can talk about color or materials or whatever else. I mean, it is definitely broader if you talk about aesthetics.
and less defensible,
Yes.
in the case.
Well, or it exposes you to needless legal expense when you have to go down that route.
Yeah, and was kind of your objection to the word aesthetic when you first brought it up, is that, you know, it's very subjective, and what looks good to me might not look good to you, and vice versa. Okay. And the same theory goes on to the next part under 383190.
Yeah, I just carried that through.
Yeah, same thought, so.
Yes. All right. I put under the proposed amendment to 383-188E3 as under the context of what you're doing here is really regulating the content of commercial speech. And the U.S. Supreme Court has addressed this issue in the Central Hudson Gas decision, where it set forth a four-part test for determining whether content-based regulations of commercial speech are constitutional. And there, to boil it down, what you have to do is there has to be a substantial government interest in doing what you're doing. And if there's not a substantial government interest, then the regulation will fail. So, and as I go through on pages 6 and 7, I detail a couple of decisions that have addressed this out of the Second Circuit and beyond. And this is where we have a conflict between the Second Circuit and the Sixth Circuit. Of course, we're within the Second Circuit, so that's where what we're guided by. But it's important to know what the other circuits are doing, because one day the U.S. Supreme Court may weigh in on this, and what we do today, based upon the Second Circuit, which is the way that I would direct you to go, might be overturned, and therefore your regulation could be invalidated at that point. So what I would suggest is, taking into consideration the fact that there's conflict between the circuits, what the Sixth Circuit is saying, it's disagreeing with the Second Circuit, but I think what you can do is, by following the Sixth Circuit, you're kind of adopting the Second Circuit, but you're going a little bit further. What the Second Circuit here is saying, I just lost my spot here, excuse me. Really, the point here is that what the Sixth Circuit has said is that the bold assertion that particular speech serves its interest is insufficient. You have to have something more than just saying this is a substantial government interest. The Second Circuit essentially says as long as there's this language in your regulation, you're fine. Since it's uncertain what may happen in a year or 20 years from now, you might as well put something more in your regulation to support the purpose for the regulation. This way, notwithstanding what happens at the Supreme Court level, your regulation should withstand scrutiny at any time. So from a durational standpoint, the only thing I would suggest here is, I left it at, you said 60 days before the expiration, and then removal 5 days after. And the purpose of that is to promote the health, safety, and welfare of the district. So you're just adding that language in there, so you're stating what the purpose is.
Which well, you said in accordance with the Second Circuit, so we're on fairly firm ground there. Plus, I think it actually is a safety issue. You want to be able to take things down, right. Not to have them up there the entire, forever.
Right.
And also, Vin, we have to, if you'll notice that the text in Vinnie's memorandum was before we addressed it, because you asked me to make that change too. We can't have different regulations for real estate signs in the commercial district than the residential district. So if you notice in the summary that we're looking at, we've changed, if you read the first one that this was initially done, it says commercial real estate signs advertising, and we've changed that to real estate signs. So the same standards would apply to all real estate signs, both in the residential and the commercial districts. And then you're suggesting that we change 3 to what you've added?
Yeah.
Okay.
It's just for purposes of the H in health, the S in safety, and the welfare, W in welfare should not be capital, but.
Yeah.
Yeah, I mean, and again, what I would counsel you at the public hearing, you may want to have discussion on the reasoning behind this. Again, it creates traffic concerns. It blocks line of sight. There are important safety reasons for the prohibition on duration.
So if I get it under 3A3, 188E3, ignoring the commercial part because we've changed that, you want to include the wording that's on page 11, is that correct? The following restrictions are enforced in order to...
Page 9.
Page 9.
Oh. I'm sorry.
You underlined.
Okay, yeah, okay. All set.
All right. Whenever you're ready.
So I'm
Okay.
all set.
With respect to 383, 188E1 and 383, 190B, The issue here is, again, that from a constitutional standpoint, the courts have held that limitation on the number is constitutional. However, what we have to, again, get to is your powers under 8-2. And again, your limitation is to regulate the height, size, and location of the sign. You don't have a regulation, the 8-2 does not actually allow you to limit the number of signs. So you may ultimately have,
It's silent on that issue?
it's 8-2 is silent on this issue.
Okay.
And the court, but from a constitutional standpoint, as you'll read, I think you're fine on the limitation. So you may have issues of judicial scrutiny on this one. But what I would suggest doing is that, since there is the Central Hudson decision where it really goes to, does this go to a substantial governmental interest, I would suggest that, again, you add language in that supports your reasoning for the limitation. So the addition, as stated in the prior one, is the following restrictions are enforced in order to promote the health, safety, and welfare of other commercial enterprises or residents in the town of Orange, semicolon, 1 sign per lot. Again, you can play with the language on this, but the purpose is that the reasoning behind the limitation is there's the health, welfare, and safety, which again is within your authority to
Yeah,
regulate.
charge under 8-2.
Yeah. And again, that's the same for 383-190B. And a lot of this is styling your regulation to just use the statutory framework and the statutory language. It's going to be hard for a court to criticize you for using the statute's language, and it's going to be hard for a court to say that you've gone beyond your authority if essentially you're bringing it all back to what 8-2 allows. And that's, it gets back to the initial statement that I made about, do you want to regulate the color? Well, for example, and we'll get to later on, is, you say signs cannot be of a certain color if it's to interfere with traffic signs. Well, again, you're regulating color, which you're not allowed to do, but what I would argue is it's not, you don't care about the color, you care about the location. If you can't locate a sign near a traffic sign that's going to impede or interfere with the traffic sign. So it's a location issue, it's not a color issue. So again, there are ways of arguing around it, so to the extent that you wanted to include certain language, let me know, I think you can. We just need to style the regulation in such a way that the focus is not on the aesthetics, the color, but on the height, the size of the location, or bringing it back to health, safety, and welfare. All right. That brings us to the size of signs. 383, 187.4, 188A3, and 188E2. Okay, in this, again, you may regulate the height, size, and location of signs and billboards. So you have the statutory authority to adopt the size regulation. And it's been held constitutional by various courts. So I think on this one, you're good. The only thing I point out is there was a decision that came out of New Jersey that held an ordinance that prohibited a real estate sign to 10 inches by 14 inches to be illegal because a sign must be of an appropriate size to allow the individual to convey the message that they want. So if you, for example, the real estate sign is the perfect example, and that's really what is at the heart of the discussion. If a real estate sign has to, have enough room for it to say either for sale or for lease, with the name of the company, with the maybe a person's name, with the person's telephone number, for appointment only, enough information on, there has to be enough room so that they can convey the information that they need to get their message out. So,
And my thought on this, just to run it by the commission, is that, instead of allowing or in a sense promoting a larger sign in a residential district, I think we should limit these signs, even in the commercial districts, to the sign that's a typical real estate sign in a residential district. There's no real reason for a 4x4 sign in the commercial district to advertise the lease of a space. The same goal could be accomplished and then enhanced by, when you're looking for space, you're really not making that decision based on seeing a 4x4 sign and saying, do 10,000 square feet here. You go down the road, you see space for lease. You call Colonial or whoever the landlord might be or the realtor might be, and you carry it on from there. You don't really just throw
What's
it
the
out
size of the present sign that we're going to authorize?
there. Well, I have a footnote in here initially that initially I did what is the commonly used sign on the post road is 4x4, so 32 square feet. In conversation with Vinny, that we had that 32 in aggregate, 16. So probably look at me.
No.
Wonder where that math came from. Getting back to that aggregate part.
Yes.
But when I spoke to Vinny, he said you really can't have those two standards in the real estate signs in the commercial and residential district. They should be the same. I thought smaller rather than larger.
Meaning the 4x4 on the residential side is just way out of whack.
Way out of whack. And I don't think, my opinion is that I don't think it's necessary in the commercial zone. I think.
What is the size that we're talking about?
Well, it's up for argument as to what we feel is appropriate. I'm guessing, I didn't get a chance to stop and measure any in the residential district, but I'm guessing they're about 18 by 24. Maybe 3 feet across, so maybe we go to 3 by 3. I don't think you're going to see a larger sign in a residential district, and I think
I got to take a look at I'm more concerned about on the commercial district side. I think we're going to get a lot of, I'm curious as to how far we are from the sign where it's going to be to the post road, and this, that I'm thinking about, is probably is farther than the typical residential sign and where that's located relative to the road that we would be looking for. So that would be the only concern that I had.
I think in reality, in practice, we don't really enforce it, but the same applies. You're not supposed to put them within 12 feet of the road or right away, regardless of whether, we have what is the regulation, we have what is in practice, and typically you see them in the residential zone right up next to the road.
But what I find most interesting about real estate signs is I think it's rather than the size, it's the post. You know when a house is for sale because you see that post with that little sign dangling, and what you do is when you see that, you kind of slow up, or you pull over, or and you go back and you look. So it's really we've grown accustomed to saying, okay, this house must be for sale. So if I'm interested, let me go back and pull up and take a closer look. It's easier to do that in a residential zone because there tends to be less traffic. You can actually hit on the brake without getting rear-ended normally. Although one would argue the traffic is probably slower on the post road at most times.
You're talking about the so-called hangman sign, the big cross deal.
Exactly. My thought on the issue was too that that you see that sign. It is familiar to all of us, the typical residential style that Vinny's alluding to, but my thought was that that's enough to draw your attention if you're a prospective leaser renter, and then you go investigate it further. You either contact the realtor, or you pull into the shopping center and you say, oh, this is the store, it's approximately X amount of square feet. Of course, if it's vacant, they can advertise in the windows, as will.
Do we have size requirements in the windows, by the way?
Well, in the proposal, we do.
Has that been passed by council?
I'm sorry, I wasn't listening.
The window
I
signs.
asked, window signs, do they have a size requirement or a size limitation?
We don't currently address, even in the proposal, we don't specify real estate signs or any type of sign. We just say signs in windows. So the same would apply if we choose to establish those standards, which I believe we have in here at 35% of the window area.
Oh, that's right. Yeah.
Again, as long as it's of an appropriate size for the individual to convey. And the other thing is, if someone's putting a sign in a window, they're not necessarily, it's not there for the pedestrian. They may want to, you're maybe 35 feet back from the road, and they want it to be big enough so it can be viewed by people in cars. So that's something you need to take into consideration.
So if a shopping center is going to be, let's assume that there are several vacancies in a shopping center, the hangman sign, for purpose of discussion, is the one that we'll see on the post road. I mean, that's what we're talking about.
Yes, yeah. That's my thought behind it. I don't know if everybody else
Well, I
has
think
my opinion.
based on our prior conversation with Vin, that it seems to me that we're on firm ground with regard to size, location. I mean, that's certainly within our parameters to regulate.
And we're going to keep it uniform between zones.
And quite frankly, in the commercial zone, I think it's a much better look than going down to seeing these, a 4x4 sign is a big sign.
It might be worthwhile to hear from the commercial real estate.
sure we will.
Yeah, I mean, they're going to have some things to say. I'm sure that's gonna-
I don't
It's
think
already
they-
ringing in my ears.
They're
They
not going to
may
be
think
happy
bigger
with
is
that.
better.
I don't think there's much question that we'll hear about that.
Anyone's
And they,
phone ringing?
and they very well could present some evidence that might change our minds on this. But I think as far as the proposal goes, it's always better to go with something that's more restrictive and loosen it up afterwards, as opposed to going the other route during the course of your public hearing.
The main thing here is that we can't, if I understand you guys correctly, we can't change the requirements from residential to commercial in terms of size?
Well, initially, we weren't even going to address the residential signs because it, quite frankly, wasn't an issue. Yeah, and it really wasn't an issue. Everybody's used to it. There's never been any problems, and if you start getting into this, you have to address every little thing that you could possibly imagine. So we had it specifically addressing commercial signs, and Vinnie said, can't do that. You have to address, if you want to do real estate signs, you have to address them across the board. So, in establishing that standard, I think I'd rather go with something lower. I wouldn't imagine that people in the residential district are, even if we were to allow this 4x4, I couldn't imagine them going out and putting up that type of sign either.
Because they don't want that sitting in their front yard.
Exactly,
I mean,
yeah. Yeah, but I do think that when I thought about it, after we were forced to think about it, from a personal point of view, I would prefer to see the smaller real estate sign on the post road than these big 4x4 triangular signs. I think the same goal would be accomplished. Perhaps I'm wrong.
While we're talking about signs and you're talking about residential, the only thing you may want to put in here, and I suppose, I'm just thinking now in the context of what if a court ordered a sign, for example, in a foreclosure situation where you have your typical committee sign, which is not your,
It's pretty much 4x4, isn't it? I'm not even sure.
I think it's 4x4. I mean, they're standard signs, but they're big signs. You may want to build in an exception unless as otherwise ordered by the court, because you don't want to get into a situation where a neighbor's calling and saying, well, geez, I got this foreclosure sign, and I know what your sign regulations are, and this is violative of that, and now you have somewhat of a...
So add language to address court-ordered signs.
The court orders,
Sorry about that. For the purposes of the commission, the signs that are ordered by the court, unless they change and there were standard orders that were recently revised, but I don't think they talk about the size. I've never seen one they're usually the same size because everyone copies from everybody else, but I'm not sure that's done by court order. It's the content that's dictated by the court, I think. I'm not 100% sure.
Could they get the content on a small sign?
Well, right, because they put foreclosure sale, there shall be a foreclosure sale on Saturday, blah, 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 da-da-da, da-da-da, da-da-da. And so in order to have, unless you're going to have, a dittoed sheet of paper where you need a magnifying glass, it really needs to be of a larger side. And since the committee in that instance is a court officer, there should be maybe some discretion there. So where it's a court-ordered sign, it's may have to
And
be...
another type of sign that kind of fits in the same bill is, when a restaurant applies for their liquor permit.
Right.
And that's probably, I'm assuming that's a
That's a similar
standard size
size.
as well.
That's
So-
the argument you're going to get from the commercial real estate agents, though, that they're trying to convey more information on that sign than, in a residential.
But, when you look at the-
Residential, all you're trying to say is that the property's for sale.
I think, though, typically, when you look at these signs on the post road, they're really not giving you much information. They're giving you the name of the realtor,
Yeah.
space available, and it's just in letters this big, and the phone number. Sometimes they'll stick
Yeah.
on, 4,000 square feet, whatever the
Yeah,
case
they
may
may-
be. But I think that much information could be put on a,
Frankly, if you're looking for space, you're looking for space. And I mean, I just went through this, and I drive up and down where I wanted to look for space, and there was a lot of those hangman signs. And, you would just keep an eye open. So I agree. I can't see where a 4 square foot sign is needed.
I don't either. And I think the key is, too, is once they, first of all, I think most people are fairly familiar with most of the realtors that operate in this area. You get a few from, from outside management companies that you might not be familiar with. But you get that phone number, and that also gives the realtor the chance to say, hey, look, we only have 2,000 square feet here, but down the road, we've got X amount, once they make that contact. And that's the important part when it comes to the marketing of it, to get the person to contact that realtor and go from there. The decision isn't going to be made by driving down the road. It's going to be made after the initial contact is made with the real estate agents that's marketing that spot, so.
We feel after we're listening to the realtors.
We can go forward with your proposal, and then we'll be
We'll take
open
it
to
from there.
comment, yeah.
I mean, as I said, we may get to the U.S. Supreme Court quicker than you think. All right. Moving forward, and I'm gonna cut this one short. 383, 18083. Again, I've stated ad nauseum, you're not allowed to regulate color. However, and this is where I had an academic discussion with my associate, and I felt 383, 18083 was really going toward location as opposed to color, because it says the sign may not be located whereby its position, shape, or color may interfere with or obstruct the view or be confused with any authorized traffic sign, signal, or device. I felt that was geared toward location. I felt that I told my associate that I'd let his opinion fly here, and I'd let you be the arbiters of his or mine. And so this is his, that it would be safer in order to omit color, because this way, again, you're removing the judicial scrutiny of, well, what did you actually intend it to mean? Again, I think it's pretty clear the sign may not be located where. Then you're essentially saying if there's a stop sign, you don't want to have an octagon red sign there. Like, I don't know, I think I've seen those little red signs that are, stop cigarette smoking, and, I'll hypnotize you, and, they put it there right on the corner, and it might be confused with a stop sign. So I think you're regulating location here. So I think you're fine with your proposal. He felt you should be a little more strict.
No, I think
I agree with Vinny.
Absolutely, it's not even a close call. You're right, he wrong.
All right.
Partner, associate.
All right. I'll let him know that you deliberated much on the topic, and
You can embellish, say
And
it was
I-
like 20 minutes.
the
or
argument
something.
was well received.
Contentious.
But, okay. All right. This, I think we're almost, this is pretty much the last one, and this is, I think, the more sensitive one. 383, 186E. Essentially what we're talking about here are that there shall be no banners, pennants, captive balloons, streamers, spinners, ribbons, or sculptures permitted in any district except for the temporary signs or banners promoting community events, including but not limited to functions or events sponsored by the town, places of worship, nonprofit, civic organizations, and temporary signs or banners as permitted by your exception. This becomes a more sensitive issue because you are prohibiting speech by doing this. You're focusing in on which groups are allowed to have their message conveyed and which groups are not. You're specifically saying the government is allowed to put out its banners, and civic organizations, places of worship. So you are regulating speech by doing this. There's also other things that you should be aware of. There are a lot of different civic organizations that could come forward and say whether it's the Rainbow Coalition, whether it's Pedophiles for America, whatever could define themselves as a civic organization. And I think it might be difficult for you in certain instances to say, well, no, what we really intended on this is when the Lions Club is having their Easter egg hunt and they want to advertise for that, that's what it's for. Or when the town is having their summer concert series, that's what it's for. What you are doing is what would you do if a gay rights organization came forward and say, we want to have a parade and we want to advertise, whether it's here or whether it's in New Haven or elsewhere. You're going to find yourself in a situation where, you may have to make a decision that you're going to end up not being able to get around with this ordinance. Not that, you're here not to deny anyone of their rights to express themselves in a forum, but what you're doing is you're saying we're going to give preferential treatment to certain entities, such as the government, such as civic organizations, such as religious organizations, and that's not constitutionally permissible. So,
We're saying the businesses can't do it, but, the
So-
government and civic organizations can.
and that's what you're doing, is you're
That's
saying,
illegal.
hey, whatever the government does is fine,
But you can't do it on Route 1.
But, right, but if I wanted to hang a banner that said, congratulations to my children for winning the spelling bee, I should be permitted to do that at my expense and express that's my First Amendment right, and you're going to come in and say, I can't do that, because I'm not a civic organization, I'm not a...
Actually, Paul would be coming in and saying it.
Exactly. So this is the one that's more problematic, and it's more problematic for a number of reasons, because you get into sensitive issues, sensitive topics, things that really can tear a community apart, and make people express sentiments that are unnecessary. So you have to, this is an area where I really didn't come to a conclusion on, because it's really your decision, not mine. And I think you need to take into consideration the public's First Amendment right to express themselves, and weigh that against what you're limiting. And by focusing specifically on certain entities, you are limiting free speech.
We want to see the banners on the post road is what it's going to come down to. Or do we want to go the other way?
Well, the reason I put that in here is because I'm not sure if we want to see the banners on the post road, but by practice, we typically allow banners. We even allow them all over town. They go across the road here. They're on, churches do it on a typical thing.
You keep doing it
Fairs
until
do.
someone yells at us.
I mean, they're always temporary, and by the time the enforcement comes around, they're probably going to be down.
Well, I mean, and sometimes it's not even a matter of enforcement. It's the town actually does it, and places of worship do it. There's a blood drive. They put out a banner.
The referendums for voting.
Yeah, and that's why I included that language, which I thought was okay. I guess I'm wrong.
Well, and the problem becomes you're prohibiting banners, you're prohibiting this everywhere, right? So again, what if I, putting aside the Orange Center Road banners, what if I wanted to, I was welcoming home my significant other, my brother from Iraq, and I wanted to put across my house, welcome home, a big banner. I'm not allowed to. Well, why not? That's,
No, I think your point's well taken, and I think we all understand it. I think the biggest issue now is,
what do you do?
what do we want to do? I mean,
You might not be allowed to do what you describe based on other regulations. Other regulations may prohibit it, right? I mean, if it violates some other, not what you're talking about specifically, but I mean, you're talking about height, size,
Sure, you
that
might-
type of thing. So, I mean, the fact that you would consider deleting this subsection E doesn't mean that you have no control
Right.
over signs.
There might
generally
there might be an out, and again, the out is where, on the one hand, I was saying, you don't, with real estate signs, you might be better served by coupling them all together. Here, you might be better served by parsing them out, because from a constitutional standpoint, commercial speech is not given as much freedom as private speech. So, to the extent I want to say something about a political official and put out a political sign, you're not going to touch that right. But to the extent I want to put sidewalk sale, shoes between, 8 and 12 a.m., you might limit that in duration, you might limit that in size, you might limit that in location. So you might here differentiate between the commercial and the residential, so that you do not infringe on my First Amendment right as a citizen, but as a businessman, you can not infringe, but limit my speech.
So,
But don't these regulations already do that? I mean, don't...
They do, but here you're
So if I understand, then we can have, if we change this to, no pennant, captive balloon, streamer, spinner, sculpture shall be permitted in the commercial district,
period.
And then because we do have a provision later on in here that allows for temporary signs, and then we go right down to except temporary signs or banners as permitted in 383 190A, which is a proposed. So we could do that. Is that correct?
Correct. Except for the word sculpture.
Okay.
There's a decision that came, I got to tell you, this was a nightmare.
I guess so.
There was a decision that came out of Hamden, Schwartz v. Planning and Zoning Commission. It was a 1988 decision where the court, in that case, a metal sculpture was erected outside a shopping mall that didn't have any lettering, logos, or anything on it at all that would direct anyone's attention to the shopping plaza. But the zoning commission argued that the sculpture violated the zoning regs because it constituted a sign and was not permissible under the regulations. But the court held that 8-2 does not provide the town with the power to regulate anything except signs. And therefore, a sculpture is not a sign, and therefore you cannot regulate sculptures.
Okay, so we can change that to prohibited signs. No banner, pennant, captive balloon, streamer, or spinner, or ribbon shall be permitted in the commercial district except for temporary signs or banners as permitted in 383 190A proposed. And that's, the whole line gets taken away if we decide we don't want to do that. Or that portion of it, I guess.
I'm sorry.
The temporary banners that I think about from the town, our original intent, I think, was we wanted to protect the Lobster Fest and to give the town the ability to get those types of Red Cross things out there. We're talking about prohibiting them in the commercial district, correct?
Correct.
Could we allow them in the residential districts?
Yes.
That's their First Amendment right.
I don't think you can, if I wanted to put up a 10 by 20 billboard on my front lawn and, again, I'll say something, I guess that would be hard to argue against. I'm not in favor of, or I'm in favor of the war, okay? And just that's it. Or if I wanted to say something derogatory against the president, I don't think you can limit me.
Nor was that our intent. Our intent was really to codify what we've done in the.
So I think
all
here you'd
along
be
in
better
our-
served keeping it
in the
segregated
commercial
to the commercial district.
Okay, so I'll work on some wording from there.
So I'm sorry, I was paying attention, I think. What was the outcome?
I'll work something along the lines that continues to prohibit them, so it would be no banner, pennant, captive balloon, streamer, spinner, or ribbon shall be permitted in the commercial district except for temporary signs or banners as permitted in 383 190A. And that would, if we don't approve 383 190A, then the whole thing becomes a moot point.
And 190A is which one?
190A allows for temporary banners and stuff to promote grand openings, that sort of thing.
And again, the courts here have looked to whether or not there's a viable alternative. And, you can argue, again, everything is arguable, that there is a viable alternative. They can put a window sign up. If it's going out of business sale, they could do that in a window. They don't need to do it in a banner. They can come in and put a permanently affixed sign on their building or on their, so there are viable alternatives.
What if the firehouse puts up a banner saying Fireman's Carnival, June
Or that-
3rd to the 8th?
Or
That would be allowed, because if we're only restricting them in the commercial district, well, that
No.
isn't a commercial
Them
district.
up on Route 1 sometimes.
But are you permitting it in the residential district?
you're not
We're not
addressing it.
prohibiting.
We're not addressing it, period.
You're not addressing
Okay,
it.
We are
okay.
ducking the issue.
Defer to the town attorney on that one.
Just
No,
the-
you are going to have an issue, if I recall, when the Fireman's Carnival comes on the post road, they put up their not their cardboard sign, their wood sign, where, in the, well, that's residential, but right on Route 1, in
Right,
front of the
in front of the
fire
firehouse there.
department, they put up their sign.
Yeah, we're going to send Paul.
So, Paul,
It'll be interesting to see who sends me. I would hate to see my house on fire.
good thing you live in
Put a
Derby.
clause, anybody complaining about the Fireman's Carnival has to leave town,
Right.
so
Yeah.
we'll include that.
It's going to happen.
It probably
But if they put
will.
it up on a Friday and take it down on a Sunday night, then
The deputy zoning enforcement officer will have to deal with it.
Just so you know, under proposed 383-198, what it reads is temporary signs or banners as permitted in 383-187-2E, which is the part we just discussed. Then it says temporary signs or banners used to identify or promote a business while an application for a permanent conforming sign has been filed and the application is pending. Temporary signs or banners used to identify or promote a business while an approved permanent sign is under construction not to exceed 30 days without approval of the Planning and Zoning Commission, and temporary signs or banners approved by the commission advertising the grand opening of a commercial enterprise that shall be posted no more than 30 days. Those are the other provisions there.
You know, and then just lastly, the severance clause. I did include the model that came out of the MILA's model for temporary sign ordinances, and I think their severability clause is pretty expansive. And just so you know, for those, there was a decision that came out of New York. The decision included about 7 towns on Long Island, and some of the towns had severability clauses, others did not. And for those that did not, their entire regulation was stricken. For those that did, only that portion was stricken. So it's always wise to have severability clauses.
Vinny, I have a question on the severability clause. Why wouldn't you include that for all the entire zoning regulation, not just the sign?
You should, but we were only addressing this at this time, but it should be there. It should be there.
This may be something Brian wants to take a look at.
Well, I think,
Well, I mean,
You want,
I
you
think
want
what-
to make that applicable to
Well-
the regulations generally.
I'm suggesting
Yeah.
that we can, it's not difficult. It's already been drafted here, and the only thing my question, which I think was answered, is if you could use this language, can we use this language in a general section of the zoning? I'd be happy to do it. I'm thinking Article 1, right?
Well, you might say, because again, ordinarily these things work best if, like in a contract, if any portion of this contract is deemed, to be illegal, then the rest shall remain in full force and effect. So it's always best if you do it within the confines of sections. So, but if you wanted to do a global where you said, section whatever, severability, and, you say something, in the event any section of any regulation is deemed to be unenforceable for any reason, the remaining portions of that section or regulation shall continue in full force and effect. So this way you put more of a blanket, and you might even just propose a new section of the zoning regs that is called severability.
And I mean, you could even do it twice. You could do a
Yeah, it
sever
wouldn't- yeah,
a
it
tire
wouldn't
for
hurt.
the everything, and if you want to put it someplace in the sign regs again, I mean, redundancy
Never
is
hurts.
not a problem in
Never
zoning
hurts.
regulations.
My
Yeah,
memo's full of redundancy.
Okay.
I've said it before, and I'll say it again.
So we should include severability as a separate article even, perhaps,
It's wise.
and then include it also in the sign regs. And sign regs. Well, I've got my work cut out for me again now.
Know what they say about laws and sausages?
Well, just
I did
something of
warn the
note.
chairman on this, for the record.
Yes, you did.
I think at the last meeting, we had 10 items, we were done in an hour. Now we have town council here, we're still on the first item, 45 minutes into the
Actually,
meeting.
Ms. Morgan, we went through a couple in your absence.
I think you started early.
Okay, well, I thank you very much.
Okay.
And I thank Brian very much, too. And we'll be having this discussion again in another couple weeks. We'll move on to review of the minutes, which is the second agenda item for the March 4th meeting. The only issue that I had with the minutes was the vote on the prior minutes. I believe Judy was
February
absent.
19th.
Yeah.
Yep. I abstained from the vote to approve the minutes on the February 19th, 2008. On page 3,
Right.
the vote was recorded as 4-0, and that just needs to be amended.
So it should have been 301. And that was the only issue that I had with the minutes. Are there any other issues? Anybody prepared to make a motion?
Make a motion to approve the minutes from March 4th, 2008 as amended.
We have a motion.
Second the motion?
Any further discussion? There being none, all those in favor signify by saying aye. Aye. Passes unanimously. The next item on tonight's agenda, for the very patient man in the audience, is a site plan application and architectural standards supplement submitted by 363 Boston Post Road Associates LLC. I hope we at least provided some entertainment.
I think so. For the record, my name is John Pruitt, and I am the project's architect. I represent 363 Boston Post Road Associates LLC, whose principal is Gary Ricciardelli Sr. of Colonial Properties and Guardian Management at 200 Boston Post Road in Orange, Connecticut. I do have a couple of additional handouts which I'd like to submit as exhibits. I have 2 copies of a colored elevation of the sign. And the other exhibit I have is basically an east elevation, which also includes a juxtaposition in scale of the sign. There are 6 copies. And now I can make my presentation. On my right is a photograph of the existing building. It is basically a single-story building which has a retail warehouse function in it. It continues into the back with a actual warehouse. There's paving and parking interspersed. And there is an existing overhang, a canopy, which has a picket fence-like trim on the top, and also has a wrought iron posts. And what we propose to do is we propose to remove the wrought iron posts and the existing canopy, and also remove the picket fence-looking device, screen I guess it is, on the rooftop. And what we propose to do is also replace the storefront glazing as well with new front entrances, which are aluminum and glass with all new front entrance doors. We're also going to have an all-new fascia treatment with the traditional crown and base molding trims. The fascia is to be constructed out of Drivet or similar material. Now, the base wall behind the pilasters and the columns is going to be stone masonry in a ledge stone-like pattern. And we noticed that in the regulations that one of the base permitted materials is stone masonry, and the client has expressed to me a desire that rather than use brick, he wants to use stone in a as prominent a manner as possible, which is to say as the base material behind the pilasters and the columns. We are also proposing stone masonry at the base of the pilasters and the columns here. And the stone masonry is in a different pattern. It is in a limestone pattern. It is about 2 feet high in each case. And so basically, the summary of the materials, your prime allowable materials, stone masonry in a ledgestone-like fieldstone profile and pattern. And for the column bases and pilaster bases, stone masonry and a limestone pattern, which in some cases is called rock face. The existing building that you see here is 19 feet high in the front. The proposed facade will make the building higher. The general height on the sides will be 21 foot 6 inches, and at the center, the main part of the entrance will be 30 feet high at its highest point. Although we have increased the height of the front facade, the building, we checked the zoning regulations, is still well within the parameters of the height restrictions for zoning. I also have, as an exhibit, which I'll pass around, which you may also place, a illustration in color of one of the products that's proposed to be used. And you can see the two different patterns that we plan to incorporate into the facade renovation. With that, I'll open the floor up to questions.
I had one question. When I looked at on page 3 of the application where you have the elevations, on the elevation facing the post road, you have it at 1,410 square feet less glazing.
That's
minus
correct.
glazing, so the net area is 1,410.
Right.
When you add up the percentages and also the breakdown, they add up to 1,310 and 92.8%. So there's an error here somewhere. If it were 1,310 feet, if that's the correct size, then your percentages do add up.
Mm-hmm.
So we need to correct that for the record. See what I'm saying?
Okay, I think, yeah, my particular handout here, I may have omitted this. I had a separate area breakdown for the center columns, which, by the way, are supposed to be fluted. It doesn't show very clearly in this. However, in the colored elevations, it does show as a fluted column. Those show on my breakdown as 100 square feet. Now, I don't know if the application shows that.
Well, it just
I
shows
thought
the
it
total
did.
elevation shows that 1,410 square feet, but when
Right.
you add up the 260 plus 40 is 300 plus 1010,
Oh.
you have 1310.
Okay, you know what? My apology, I have a separate figure of 100 square feet for the fiberglass painted columns, and that's where your
Okay.
error comes in.
But also so the percentage of acceptable materials would also increase because you're going to have the limestone base on those columns as well, correct?
Okay, we do have a figure on the stone masonry column bases of 40 square feet. So, we have an 18.4% figure for the stone masonry on the front elevation and 2.8% on the column bases. So now you're pushing 21% for the total stone masonry.
Right, we have that, but that's, there's still discretion there. Because you have the stone masonry at the column bases
Mm-hmm,
at
right,
40 square feet,
right.
which you have listed at 2.8% of 1410. But it's,
That's correct.
which would be correct. If you had that at 1310, it's 3%. But what I'm saying is, the 1410 still isn't accounted for in here. So I just want to make the record clear. It really doesn't have much of an effect. We're only
Right.
100 square feet.
Right.
I just want the application to be correct.
Mm-hmm. Okay.
So we can, if we decide to move forward with it, we can make our decision pending, and just have that as a requirement of the application, that figure be corrected.
Okay, I think the figure would be correct if we had, and unfortunately, this is my omission, the figure for the columns, which is 100 square feet.
Okay, but the problem there is that
And
That would bring it
be
up to the 1410,
Right.
and then our percentages don't add up.
Well,
So
what
one
would
of the two
happen-
has to be corrected,
Yeah,
either the
what would-
square footage or
yeah.
the percentages.
Okay, what would happen is, if you put the columns in at 100 square feet, you would have a 7.2% figure, and then your percentages would add up to 100%, or they
Okay,
should.
yeah, they would. Okay, so just if you can include that information if we go forward with the application, just so that the
Okay.
record is clear.
John, if you could just tell us where you circulated cultured stone products, and you I think it's you that circled two particularly?
Yep.
Okay, can you tell us where they're going to be?
Okay, the one that is the,
White colored one.
yeah, the...
Granite rock face?
Yeah, is at the base of the columns.
Okay, the base of the columns is where your limestone pattern is, or rock stone. The background, or the main wall surface, is what we call,
The Carmel Country ledgestone?
right, the ledgestone.
And that's just fascia, right? That's not actual stone.
Well, the owner may elect to use actual stone. Basically, what this product is it does use cement, it does use lime, just like masonry, but it isn't a cut stone per se. But the owner may indeed elect to use a cut stone which is identical to those patterns. And it would look just like that.
And this is the area that's going to face the post road. What is the owner going to do with the side of the structure?
It is, one side is addressed, and the other side in between the two buildings isn't addressed. Is that going to have the same pattern wrapping around?
What the owner is going to do on this side is he is going to continue the fascia and to drive it for 6 feet. Now, by the time you get beyond the 6 feet, there's perhaps maybe 7 or 8 feet between these two buildings, which you can sort of see in the existing building photo illustration. So by the time you get beyond the 6 feet, it's not going to be visible at all. But on the side that is facing eastward, that is going to be visible. And as you can see on the east elevation, we're going back at least two-thirds, perhaps three-quarters of the way along that wall, including the first 2 bays in which we are putting in 8-foot wide windows and also carrying that stone pattern around the corner. So that is significant. He wants to do that because he knows that that's going to be visible, and it will be because there is about, I would estimate, 100 feet between that elevation and the side of the firehouse, which is next door.
So the east elevation is clearly visible, is your point?
Yes.
You say it's going to go back somewhere between a half and 2/3 or something like that. What's going to be the remainder? Is going to be the brick that's out there? It looks like some kind of stone.
Yeah, it's basic. It is a concrete block wall, and he'll just paint that out.
So this depiction here of the east elevation, there's, how much of the building, this is about 3/4 of the building, you're saying?
That's about 75 or 80 feet back, yes.
Okay. And how deep is the building altogether?
100 feet.
100 feet, okay. Any thoughts or questions?
Clearly a vast improvement over the existing structure, so.
I was somewhat alarmed when I looked at the percentages, because they're fairly small, the total area of approved material. But in looking at the proposal, as Judy pointed out, it's a tremendous improvement over what's there. And in addition to that, looking for ways to add more of the improved materials, I think we'd be throwing them on there without getting any aesthetic improvement on the building either, which didn't seem to make much sense to,
Is the cultured stuff, the stuff that we just looked at, is that part of the approved materials? I don't even remember.
Well, we don't address the cultured stone specifically, but it really is a masonry treatment. It's, you wouldn't,
It's real stuff.
yeah, it's not,
It's
yeah.
masonry.
It's
yeah.
masonry.
They want to use masonry.
This stuff you really wouldn't, I think that, in answer to your question, I think we would consider it masonry, first of all, which, would be a brick or stone. I don't see the difference, I don't recognize any difference. But in looking at this stuff too, I've seen it, in practice, and it's, you couldn't
Looks
tell it
like
from
real
natural stone.
stone.
John, they're redoing the sign as well?
Yes. That is the purpose of the handouts. One of the questions on the architectural review application does pertain to the sign, and one of the things that we want to do in our final sign design, besides, as best as possible, comply with the zoning regulations in terms of areas and the like, we want to design a sign which basically complements the new fascia. And you can see all of the various elements in this sign, and which also have their direct relationship with the fascia. Now, there is an existing sign there right now. It is about that height. The base is existing. That's basically all we're going to save is the base. And we're going to build a sign right on top of that existing base. We're going to face the base off with limestone, and we're going to have a column design that's in similar spirit to the pilasters that are on the proposed new fascia. So that is what we're proposing as a ground-mounted sign. And that's it.
John, is there any, I assume that the sole reason that the principal didn't take the new treatment on the east side of the building all the way back was a cost factor? Because it looks like it's visible.
It's more like a visibility factor. I mean, we've obviously visited the site, I've walked the site, and the farther you go back, the less visible it is. As a matter of fact, you come across a fence, I believe, before you actually get into the back of the site, in the back of the building itself. So the owner may elect at a later date to indeed continue the treatment all the way back. But
This additional fascia here is not going to continue to the back of the building. It's going to cut off if this is 75 feet, this is going to be what, 60 feet, 65?
basically, it's going to discontinue there, because at that point, there really isn't fundamental visibility. What there is, however, and this is very important to bring out, the reason the fascia even continues that far back is we're using that fascia to screen off a very large mechanical unit that comes very close to the edge of the wall there. So now we have a visible aesthetic screen for that mechanical unit that's high enough to conceal the whole thing.
John, what are the black, are these awnings that I'm looking at, the black?
Yes, those are awnings.
Canvas type, or what is?
They're canvas awnings.
Okay.
Now, one of the things I wanted to show you with the elevation drawing, I have an elevation of this without the awnings, so you can really see how the stone works. Because in a lot of the colored illustrations, what happens is the awnings conceal some of this stonework.
So the material behind, if you remove the awnings, there would not be stone behind the awning, according to that picture at least.
Well, the stone does continue beyond the awnings, but visually,
Oh, I understand.
if
Okay.
the awnings are put on, it does conceal the stone. But the stone continues all the way across.
It's the same stone that we're looking at
Yes.
in between. Okay,
Yes.
yeah, it doesn't, I think Bo's saying it doesn't look like it
Doesn't
from
look
the
like it on
picture.
there. In other words, if what you're saying is that the awning is shielding some stone,
Yep.
that's not reflected here because you would see stone down here.
No, you would see glass here, but you'd see stone here. Now, now the awning actually
This is
starts
glass that
here.
goes up this high? Okay.
Yep, that's
Okay,
glass. The
that's-
glass goes
yeah.
up 12 feet high.
Okay, that's right, that's where the misunderstanding came in. Thoughts or comments or questions from the commission?
I think Judy said it right. It's a vast improvement from what it looked like for the last 15 years or 20 years that I've been around.
I think we're down one temporary Halloween store, too, actually.
That wouldn't be a bad idea.
How soon can you get this done?
Well, I got to tell you, though, I mean, in a perfect world, I would love for them to take it all the way back, but I can't, I must have passed this site 100 times, and I can't tell you as we sit here, whether or not you can see it as you're driving by on the right, that right side, meaning the east side.
Yeah, I kind of share that concern, that it would look kind of haphazard if we go down a certain...
This is right near the fire house on the
Yes.
post?
Yeah.
It's right next
Do you
to
think the owner would consider, for symmetrical purpose, just for the first two panels on the west elevation to be identical to the ones on your east elevation? The two windows.
The west elevation is not visible.
I think that's the one right next to that other building that you can't...
It's the east elevation he's talking about.
Well,
But I'm
I think
just-
we're talking about two different things.
Right.
I think Judy's concerned about the west elevation, and I think she's correct there, because it kind of would look odd if it's...
Unbalanced.
Yeah.
Again,
But it's
without
not
looking
visible, though.
at all.
It's not visible, that's the
At all.
problem.
It's only a
Okay.
6-foot differential
This-
between that other building
That's-
and
yeah,
the subject.
that's correct. With the east elevation, well, that's exactly what we're doing. We're replicating the materials and design and feel on the first, on
What is
the two
what
windows.
do we have anything showing the west elevation? Or is it just going to be cement block from the west corner?
What we're going to have on the west elevation is the fascia returning 6 feet. There's no drawing in there because there really isn't significant
So-
improvement to
But just the fascia is going to go back 6 feet, but what's below the fascia?
What's below the fascia is going to be the drive-it treatment and the column will wrap around the corner.
So the column's going to wrap around the corner,
Mhm.
identical to the east
Yes.
elevation, and that
Yep.
goes back, what, 4 feet maybe?
Yeah, that column wraparound goes back about 3 feet. And then you'll have another 3 or 4 feet in a panel, and then it'll end right there.
So the-
We should have a drawing for the record, right? For the app.
I think that we might want to,
If not on the west side, I certainly want it on the east side to see how,
He's got one on the east side, but on the
Have
west
an east
side.
elevation.
well,
Why
Paul's,
wouldn't-
we're going down two different tracks. Paul's concerned about the appearance of the drive-it ending, or at least wants to, if I'm not mistaken, you at least want to get a look at that. And Judy is expressing her concern about the west elevation and what that's going to look like. And I think that we should have an elevation just to show it, and that'll also give us time to all of us get out there and take a look at it and see how important we feel it is to address that west elevation, at least to a certain point.
It may not, after looking at it, seem like it
May
makes
not be
sense
an
at
issue,
all,
but-
but
I think that's...
But I would say
putting
just,
forth a fabulous project, so maybe we just, with a little bit more time, we can make it, even better, I don't know.
well, I would say we should at a minimum include a drawing that shows what he intends to do on the west side.
Yes.
I can get Paul a drawing of that. Because we're into working documents on this, and that drawing, in fact, was made recently, so I could get him a drawing like that. It's not a problem.
So I think we should hold off any action on this until, if I'm reading what the commissioners are saying, that we should hold off action until our next meeting on this, so we can get a west elevation and then decide if we feel that it should be addressed in some manner other than what's been discussed.
yeah, I mean, if it's not visible on the site as you're driving by, then I have less concern.
Right. And your concern is also is the visual impression on the east side, just to make sure.
Actually, that's what
Yeah.
that's what I was
But
saying.
I think both are important. I think,
We should all take a drive out there.
yeah. So I think that that's the best, best plan is that we take a look at this, and get the west elevation of drawing, and revisit this again at our next meeting. Okay?
All right.
I already gave them up.
The next item on tonight's agenda is a re-subdivision application, Farm River Estates, submitted by Farm River Estates LLC. The proposal is to re-subdivide 22.78 acres of residential zone land into 9 lots. It also calls for the extension of St. John's Drive and the construction of Farm River Drive, which would be in excess of the 1,400 feet. So our first order of the day when we do this, and I did speak to Rick too, by the way, and asked him if there were any items on the agenda that he wished we would hold off taking action on with him not being here, and he did not object to us going forward with this. I just wanted to make that clear that I did ask him if he objected to us taking a vote on it if we go there. So I guess we should broach the subject of the extension of the cul-de-sacs beyond the 1,400-foot limit. That is in 38323G1, and it's allowed to go forward under 38323G4 by a three-quarter vote, which would have to be a unanimous vote, seeing there's only 4 of us here this evening. So I guess before we go forward, are there any objections or concerns about extending those cul-de-sacs? One would be, if my memory serves me well, 1,920 feet in length, and one would be 1,455 feet in length.
Also in discussion, you wanted to vote on each one separately.
Yes.
Sorry, I missed that one.
He thinks we have to vote on them separately, yeah.
That's what you set up in your discussion.
Okay.
Was there any concern on the fire department's part?
No, we had letters from the fire department and police department on both. And the third portion of that is the traffic, and do we feel that there's going to be a negative effect on traffic on any of the intersecting roads? We're talking 9 lots. I don't feel that that's an issue.
What was our, when I say our, the committees or commission's initial, why did we make it 1,400 or whatever it was at the time?
Well, it used to be 1,200. Then we had a proposal to bring it to
1,600, and I think we just split the difference to a degree.
I think what, in part of the discussion back then, the lot size increased. So there was actually no net gain of lots.
Well,
There was some
actually-
discussion along that line.
Well, no, because it was, the change was well before we did the lot size. And I can tell you a little bit more history about it another time. But I think Mr. Gordon's comments on the issues with the cul-de-sac extensions are very true to do when we change the frontage, is that the whole issue of this was safety, how many people are exposed to being on the cul-de-sac and so on. And his analogy when he used or analysis, I should say, when he used the previous lot size compared to the current frontage, we have much less exposure, even with these much longer roads, than we did under the previous regulation. And I think that's really the main issue. And plus, when we had the other cul-de-sac extension, typically we didn't have a lot of roads that had town water. So, water pressure or distance to a hydrant was also a major concern, and that's why we had the fire and police in there. I have no objections to the length of either of these cul-de-sacs being extended. I think it's, they've demonstrated that there are no safety issues. Both fire and police have agreed with that, and the traffic is not going to impact the additional roads.
I certainly can't see why not. I would, move that we approve it.
Okay, we have to have separate motions on the extension of each road.
So one is St. John's.
So the first one is to approve the extension of St. John's Drive beyond the 1,400-foot limit as described in 38323G1. So if somebody wants to make a motion to that effect.
Okay, I'll move that we approve the, was it re-subdivision?
Well, this is the
The extension of
yes.
St. John's Drive to a total of 19,
No, St. John's Drive would be 1455.
1,455. Do we want to I'm going to just hold my motion for a second and ask, under 383-23 GI,
G1.
G1,
G1, that's the one that sets the standard of 1,400 feet.
are we changing the actual zoning reg? Or
No,
just-
no, no, no,
we're just
no.
We
waiving?
have the ability
We're waiving it
to
under
waive.
38323 G4 is the provision that gives us the right to waive it.
All right, so I guess my motion is to extend, to approve the extension of St. John's Drive for 1,455 feet, under 383-23
No,
G.
let me correct you, Paul, it's 382, because these are the subdivision regs, I'm sorry.
382-23 G1 as permitted under 382-23 G4.
Correct. We have a motion.
Second.
All those in favor signify by saying aye. Aye. Passes 4-0. The other street.
Farmer Road.
And I'll also move that we approve the extension of Farm River Road for the total of 19...
Creation.
Creation? Okay.
Yeah, construction is a better way.
Yeah, construction of Farm River Road for a total of 1,925 feet? 20 feet?
Yeah.
Also under 382-23 G1 as allowed under 382-23 G4.
We have a motion.
I'll second it.
Any further discussion? There being none, all those in favor signify by saying aye. Aye. Okay, so we got that part out of the way. Now we have the re-subdivision application to re-subdivide the 22.78 acres of residential land into 9 lots. I do have an issue with the lot lines, primarily on, what is it, lots 6 and 7. Lot 2 kind of shares the same issue, but it's not so much of a concern to me. These, if you recall, they refer to them as the handlebars that go across. And in looking at our regulations, again, it's under the subdivision regulations, under 382-21G. It reads, lot lines. Insofar as is practicable, the side lot lines of all lots shall be at right angles or radial to the street on which the lot has frontage. And then it goes on to say, it shall be within the discretion of the commission to disapprove any lot crossed by a municipal boundary and so on. So it's kind of a weird way to include those two things in the same context. But I think that's the key here is that insofar as is practicable. Clearly, by practice, they could establish lot lines in this 22.78 acres that don't have these crazy jogs in them.
They would probably lose a lot in doing so.
I don't think they'd lose, well,
For him saying, the testimony for Mr. Weiwei, saying that he was right to the end on a couple of the lots.
it's right to the end on a couple of lots, but don't forget, they also have another lot there that they want to come back and try to split. For me, the reason I object to this is the wording practicable. It's not our objective to have to let the developer maximize the potential of the lines if it deviates too much from our regulations. And I just when I look at those lot lines with the long handlebars, I think really, to be honest with you, in one sense, I compliment the architects for their creativity, and I think it also points to some problems with the way our regulations, when we did the lot lines. As a matter of fact, it was Jeff Gordon that I had a discussion with at prior time, that when we established the 60,000 square feet as opposed to 40,000 square feet, we really did nothing but make larger lots. In other words, we didn't establish any green space or anything like that nature. He had mentioned that a better alternative might be to have them come forward, almost like you would have to do with a cluster housing development. You could demonstrate that, look, I could create X amount of 60,000 square foot lots, but what I want to do instead is have these 40,000 square foot lots and put the other 20,000 square feet into a green space or something like that. But that's for another time and place. I object to the way those lot lines were. I don't think that it's a practical way to subdivide the property. And I think that's enforced by 38221G.
Did you run this concern by town attorney?
I did mention to him that that's my objection, and, he
He feels we can have a defensible position.
he didn't, he didn't object to it,
Paul, do you recall another subdivision application that had such creative lot lines?
Nothing similar.
I don't recall either.
We have had some that have, what I would call, not common lot lines, or not typical lot lines, but I think that it comes back to that word practicable. And in some of those cases, I don't think there was any other way to reach your objective. Where here, I think there is a way to reach the objective of subdividing the land.
I was going to ask, what was the reason for doing it that way? What was he trying to accomplish? Was it simply to get another lot? Do you think
Meet the
that's all it was,
regulations.
or?
Well,
Pretty creative doing it this way. If we register an objection with them, let's see what they come up with to meet the
I
regulations.
think the applicant responded that he wanted to, I don't know, what.
the
he say he
applicant
wanted
did
to
respond
give-
that he wanted that, their response was that they wanted to create access to the town-owned land, to the open space. But two things to keep in mind, as I think Mr. Weiwei pointed out, and I mentioned it also the last time, at the time, the first selectman was negotiating with Mr. Olson to try to obtain some of that land behind that as for open space for the town. And since it was brought up during the public hearing, I can tell you now that that has been achieved. They do have an agreement that comes all along the back of those lots. So again, it comes down to what is practicable, and if that's the true objective, I can show you the map. I don't know if
When did that occur?
it was well in the works, and that's why I mentioned, Mr. Weiwei mentioned it, and also I mentioned it before the close of the public hearing. I think it was, finally, they were in agreement in principle, and I think the final agreement happened this morning, actually. I spoke to Mr. Olson in the parking lot, actually, when I came up here, and, he said he just agreed to everything that they had proposed.
When he drew the lot lines, it wasn't a
He
consummated
was
deal.
aware that it was in the works, but it wasn't a done deal, I'll put it that way.
But that certainly was the intent of doing that because he meant,
Well,
he meant.
Yeah, I do.
know-
I recall that was the reason he gave for doing it.
Yeah, and again, if you recall, when he gave that as a reason, I kind of gave it a little chuckle, because, I questioned whether that was the true motivation, to provide somebody a walking path to the open space. I think it was more to meet the regulation, to meet the requirement. If you recall, one of those lots, upon further review, did not have the required amount of space less than 10%. So I'm not sure if the commission feels the same way, or if you feel that is enough a hook to hang our hat on or not.
I think, do we have an agreement that, at least that we're interested in being able to access Olson's, the land back there? Or can we access it a different way?
Well, can we access it? You mean
Meaning
the town?
the town, yeah.
That has nothing to do with the town's access, and even these handlebars wouldn't be for town access. They would be strictly for access of the people that own these two lots. That's like saying, I want to get to the town property, but I don't want to cross my neighbor's yard to get there.
Right.
I want to have my 15-foot wide walking path to get there.
Your point is they can walk around the block like everybody else and get to wherever they have to go.
Yeah. That's my feeling on it.
I'm just thinking about mowing the yard. You're going to have to take a triangular,
Whatever
it's a little-
who knows if they would ever even mow it? But you have what would in perception be somebody else's backyard, and who knows? It's in the way backyard. Maybe you want to store something back there out of sight. Now you find out that the shed you put there is actually 10 feet over on your neighbor's property, and
It's not the kind of shaped lots that we want to promote.
I don't think so, and I think that thought is, if it was just my feeling, well, my feeling doesn't count for anything unless it's backed up by something in the regulation. And I think the regulation, as I said, it clearly reads, lot lines insofar as practicable. The side lot lines of all lots shall be at right angles or radial to the street on which it has frontage. So you can come off on a crazy angle, but this comes off on an angle, then just way over this way. And I think, in my opinion, that is contradictory to 38221G and the intent of that regulation.
I gotta tell you, I don't love the fact that Paul can't remember any other lots that look like this.
I don't think there's any, in my time on the commission, I don't remember any being so dramatic. We have had some that, you know.
And they're not
little-
perfect squares or rectangles,
Yeah.
but this is truly interesting.
And I've seen some that were a little awkward shaped, I'd say. But again, you know, they were on areas where it might not be practicable to divide the land unless you did it in such a manner. You know, and that's kind of what I made my decision on. I'm not sure if the rest of the commission feels the same way about it as I do, but
And based on the look of the lot, I don't disagree with you. And if it's just these two lot owners that have to access that property, I'm not thrilled with the shape of the lot
yeah,
either.
it does nothing for public
Right.
access. It's strictly, you know,
For
this
that-
would be
these two
private
owners.
property.
What's the general shape of the entire property being subdivided? Is it rectangular?
Of the entire property or these two lots?
No, the
Well,
entire parcel.
you have the latest one there, the December one?
Because if the entire parcel isn't rectangular, then it may not be practicable to have.
We had another one that, no, this is it. I'll put it up here. You know, my point is that my point is that when you have all of this to work with, there certainly should be another way to achieve your minimums without having to do this.
Well, maybe it's got something to do with the wetlands on the property then.
Well, my feeling is, and you might not share the same feeling, is that, again, that doesn't, just because he has a problem here, I mean, it doesn't say that this is this lot here was one that they could, there's nothing to say that in practice, they couldn't shift these over to gain the necessary space without doing these handlebars. You know, the reason they don't want to do it is because that would eliminate the chance of this one, which isn't a sure thing anyway. It's just that they feel that there's enough space. There's 129,384 square feet, but I guess there was some question with the septic system, if I'm not mistaken. So they want to leave that option open, but yeah, I don't think that's. It's not our responsibility, I don't think, that to maximize the developer's potential if it contradicts our regulations. Nor is it our, nor can we minimize his potential if it does not contradict our regulations. My feeling is that it does contradict our regulations.
It's an interpretation, because they meet the regulations of lot size and
Right.
dimension.
Right. And all other parts of the lots, it's just the lot lines, that provision for lot lines.
Yeah, I'm not so sure what the regulations mean when it says insofar as practicable. I mean, what I was getting at before was if the entire parcel were irregularly shaped,
Right.
oval shaped, circular,
Right.
in shape, then it would be difficult, if not
Correct.
impossible, to have lot lines at right angles or radial to
Correct.
the street.
I would agree.
But this appears generally to be rectangular.
You have enough room to play with, I think, is
Yeah.
is the way I
The issue
look
is
at it.
self-created, is what we're saying.
So if
That's my-
if that's what insofar as practicable it refers to, the shape.
Practicable, actually, is what it is.
Yeah, well, okay.
Wait, and I looked it up because it wasn't a word that I was familiar with, and I thought it was possibly even a misprint. And the definitions is capable of being put into practice or being done or accomplished. So I think clearly they could accomplish or put into practice lot lines that are at right angles. You know, and I agree with Ozzy, if the lot was of such shape, and I think that's the case where we have had lot lines that were irregular, yeah. That was the case in those events, that, you know, look, it may not be pretty, but there's no other way to accomplish it. Whereas I think here, there is another way to accomplish
Do
it.
you think that's a fair read of that language, Paul, or, you know, that...
I think that's, it's up to you guys to determine. I think that's within your authority to certainly
Well, also,
arrive at that conclusion. I think the regulations would support a decision.
My respect, what else could it mean? You know, why else is it in there if that's not the intent of that particular regulation? And I couldn't think of another way it would apply or circumstance when it could apply except for something like this.
A developer could say it isn't practical to do it any
But
other
it's
way.
not practical, it's practicable. So it's,
Either way, I'm not thrilled with the handlebar nature, and for future owners of this thing, I think your point was well taken, that you're going to build, are you going to build a shed out there, you're going to build a pool out there, are you going to put anything out there at all, which is my land, which is not my land. I think it's very difficult to keep. I don't like the look of it. I agree with you.
Ozzy's not comfortable with it.
I hear what you're saying there, but I don't know that that's necessarily our problem. I mean, people enforce their boundaries all the time, right? So.
Well, not necessarily a problem, but clearly a concern that we want to have for lack of a better term, an orderly development or subdivision, something that, that's...
Yeah, but the worry that, somebody may put a shed or improve the property in a way that encroaches on the adjoining property, I mean, those are...
If there was no other way that they could do it, I think if they meet our regulations, that's one thing. But here, where they have so much acreage, to have a lot that looks like this, I think that's a tough sell for me.
That was my tip, that's what tipped my scales also, is that...
I mean, I agree it's a tough sell, and these would be two of the most unique lots in the town. I just want to be sure that we can legally, deny the re-subdivision application based upon that section.
Okay.
We have to make a decision tonight, or no?
No, we don't.
I think I'd want to run it by Vinnie formally, make sure that he's comfortable in the position. I can't think of another reason that they would say that word unless there was no other way to do it.
That's the way I interpreted it, and that's, I think that's fine. We can run it by Vinnie, and just to make sure, just for, for what it's worth, when I did run that by Vinnie, he was kind of like, look, if that's the way you interpret it, that's fine, but I could understand somebody wanting to hear that from the horse's mouth too, that's fine.
I don't mean that we have to have him coming here, I just mean...
No.
He may have not understood that, he may wind up in his desk.
I think it's, I looked at it, quite a few times and did as much as I could to try to look at it from both ways and see if what kind of an argument I could make for the opposite view.
What about, could that be referring to conditions at the site? I mean, wetlands, other conditions of the, if there were topography, the rock formations, I don't know. I mean, is there something that, that if you took those...
I don't think that's what Mr. Uwe said. I think he was down to the bone, and the way I took it is that he needed to, if he was going to make those...
He needed to get that square footage, first of all.
So
Right.
What he was trying to accomplish...
Is get that
is
second-
another-
Yeah,
get another
those two
lot.
lots.
if you
yeah.
backtrack, initially, we did not have these lot lines. It was only after it was pointed out that they didn't meet the minimum requirements for the, and I have that...
Strange shape came about.
Well, and I think you're right that, the reason they gave for doing it this way was to create access to the...
That's the reason they gave.
That's what I'm
That was the
saying.
best reason they gave.
Yeah,
But they-
that was the, I'm just saying, that's the reason they gave, that was it.
If you go back to the original plan that was submitted to us, they weren't concerned about it at that point.
Right.
So, yeah. And now, as I said, the first selectman did negotiate with Mr. Olson, and we do have town land that goes back to, probably right here, if not all the way to the edge. But like I said, on the initial proposal,
Well, I just wish that, we had knowledge or had raised the issue of that regulation during the public hearing to hear
Well,
how he could respond to it.
I did. I did bring that up during the public hearing, and his response was they wanted to give access to the,
That's
Do we refer specifically?
to the
I did, yes.
regulation? Okay.
Yeah.
Well, I would think that we could continue this till next time, and we get a strong opinion from Vin.
Yeah.
Okay.
Yeah, I would agree with that.
Fine with me. All set? In that case, we've concluded the agenda items, and we'll ask for a motion to adjourn.
Move to adjourn.
We have a motion.
Second.
All those in favor signify by saying aye. Meeting adjourned at 9:35.